has sort of a uniform hairstyle, that the back of the hood looks as if it's empty. Now, obviously, it's lifted up off his head, but the back, it's got just fabric. You compare that over to the shooter, that is a different head. That is a full hood. That is hair, that is something up underneath there. Not that hair. Those are not, I'll go back and forth, those are not the same heads. Mr. Cooper got up on his closing argument and he said, Hakeem Robinson is 6 feet. And again, we're talking about tailoring the evidence, trying to shrink Hakeem Robinson, trying to grow the shooter, trying to jam a square peg into a round hole. That is not what the evidence was. The evidence for his height from first Blue, are we to trust him or are we to not? Because he said 6'2", 6'3". Johnny Shipes, no motivation whatsoever, not in handcuffs, not looking at prison. He said, I'm 6 feet. He's a lot bigger than me. He doesn't even fit into my clothes. Latham got up on the stand. And that's not what Latham testified to. He goes, the government did not ask me to do a height assessment. He agreed that the poor posture, not measuring for height, was 6 feet and a quarter inch. But he also said that there is a error of margin, very small. And we talked about the black tape line. I asked him, and I go, how thick is that tape? And he goes, could be 1 inch, could be 2, could be 1.5 inches. Again, I wasn't asked to do a height assessment, and you can clearly see that Hakeem Robinson is taller than that. And then anybody knows you get your height measured. When you go to the doctor's office, that little square is so small, so it forces you to put your feet together. You can get an accurate weight, you can get an accurate height. Again, they are trying to shrink Hakeem Robinson to fit. Stand up. You don't have to go based on that. You can look at him in this courtroom and make your own determination on the size of this man. Sorry, can we back up? And also the size of his feet. You can make that determination on your own. And when you do that, you can take a seat. Go back and look at the tiny little feet on the shooter. Latham said he would have the ability to be able to figure out the length of things. He spent nearly $100K on that guy to get up here and say, yeah, maybe. You don't throw in a few more dollars to get an accurate measurement of that foot? Go now to Sergeant Smith. February 5th, he's already committed on who it is. That's not an investigation. Literally days later, he sees an Instagram post. Now, what he says is, I screen recorded the Instagram post. We don't have the other Instagram stories to know what other things were out there. He just found one and he's like, this is enough. And he then commits to subpoena the meta records of my client. He had a print before that. We embrace that. That print was on that gun. It doesn't mean that he was ever inside of the car. And you know that he was in a music video holding all his buddies' guns. He was committed at that point in time. Print, post, he was done. His job was done. That's my case, but it wasn't enough. We got to build it a little bit more. Now let's compare this over to the other people that we know were involved. Barner, Butter, Blue, Abdul Sr., Abdul Jr., Torgon Williams, Natalie Bryan, Chris Brown. None of them posted anything. We use a phrase in these courtrooms every now and then, consciousness of guilt. That's consciousness of innocence. I'm going to post something, would be wildly, days later, wildly stupid. The only person that's going to do that is somebody who is confident in their innocence. I am using this because this, unfortunately, and look, I don't condone it. I'm not a drill rap fan. It sells records. And it gets followers. But him co-opting a lifestyle of people that grew up around him as an artist doesn't mean that he's the one that committed it. I mean, look, country music stars talk about, murder. And look, I understand somebody actually died here. Rock stars will scream about murder. Other rappers will do it. We don't say that's a confession. But when it's a 21-year-old black kid from Jacksonville, it is. We're talking about the government and the way that they're trying to tailor the evidence. An opening statement. Mr. Cooper got up here and he showed you that post and he read it. I am never going to read that post. I don't have that right. First, they're assuming that's what it means. Right? Somebody could have a good day in court, post online, I killed it today. All right, so they want you to speculate that's what it means. But let's assume arguendo, that's what it means. So the government gets up here and they go a couple days later. A couple is 2, not 5. And then he says, getting his tired feet to try to say, oh, he ran and then went and got a pedicure after that. Again, 5 days later, nobody else is posting stuff. Everybody was trying to get away with his crime, and apparently he just goes out on public to his hundreds of thousands of followers, JSO watching, and confesses. The problem is that, look, there's 2 ways that you can look at the world. You can look at it through clean windows or dirty windows. You look at the world through clean windows, you're looking at it objectively. You start looking at it through dirty windows, everything you see is dirty. And that's what former Detective Smith, now Sergeant, did. He committed, and everything he looked at for Hakeem Robinson was through dirty windows. He was a hammer. That kid was a nail. He didn't look at anything else, despite the fact that there is clearly motive of other people. Chris Brown. We're not arguing that Chris Brown is the one that committed. I don't come into court and make speculative allegations. There was more than enough to look at it. So, Chris Brown. Renata Boston says that the guy that comes out of the woods has shoulder-length dreads. Natalie Gant gave us that little tidbit as well, too. Oh, yeah, shoulder-length dreads. Didn't have shoulder-length dreads, not even close. Butter pecan skin. Now, it's clearly more brown than it is my client. I can't say that I confidently know what butter pecan skin is. I'm thinking of ice cream, but I'm thinking that it's more close to this guy. But there's one other glaring issue with that. Rothermill case. The murder crew is blue, butter, and brown. Crazy Chris. They literally have another murder case tied to Willie Addison. Smith gets up here and he goes, I don't even know his phone number. Talked about it in voir dire. You have to objectively investigate. You can't commit to a case, to a murder case, that is going to change the lives of so many people 2 weeks into the case. If he were looking at this case objectively, he would have looked into Brown. Oh, and don't forget, and I almost forgot this, Barner said Brown was involved. Now, someone would ask, well, why would Barner do that? I'm not asking you to understand the motives of a reliable hitman. I can't get inside of that guy's mind. I don't think any of us can. But is it crazy to think that in his mind he's thinking, first, I got to go with their narrative. But also, the more people I give them, the better my deal's going to be. Yeah, Chris Brown on 2 cases. It's not going to do much. But if you get more people, you can say, I gave you all of these people. there was plenty of people that had a motivation. It came out through Latham, it came out through Brown, it came out through other witnesses, that there was plenty of other people that would have been upset with what Charles McCormick did. None of them were looked at. None of them were evaluated. Instead, they spent the $100,000 to say that it wasn't to other people that we were never arguing that it was. They never acquired any records of Chris Brown. His Instagram, his cell phone records, nothing. Same thing with Dominique Barner as well, too. They don't get his Instagram stuff, and he said that he was on Instagram. He used it to stalk his prey, and also his iCloud stuff. It's willful ignorance. Now, I'm not saying that Smith sat down and go, you know what, I'm going to jam this kid. I'm going to make a choice not to look at it. But he lacked all objectivity within minutes on the case and didn't look at anything else, wouldn't even consider it. Let's change gears now and talk about House of Pain. So we're going to go into the topic now and talk about all the communications and the cell stuff. The government, like they're trying to link, they're trying to shrink Hakeem Robinson, grow the shooter. They're trying to bridge a gap as well, too, with the cell phone communications. They're invisible dots, imaginary lines. They're trying to get you to speculate. Now, first, they're trying to both say that, Hakeem Robinson was involved, that 478-305-9583 number, that was his, that he was using it. They're trying to connect all of that. But that's not what came out. They'll argue it, but it's not what came out, and that's why we're going to go over it here. First, with respect to the House of Pain email account, and they're trying to say, well, there's selfies of Hakeem Robinson in that account. Now, we know that Blue was trying to be the manager of his son, especially when his career was taking off. And any Apple iPhone user knows that you can combine, you can share photo albums. You know what makes sense as well? Something that they haven't disproved because they didn't get any of the further records, that he's uploading photos to his father's account so that his father can manage his Instagram page, to do something as a manager to justify getting payment. I'm not saying that's what happened. I'm saying that there is a hole in there that they're saying, well, they're selfies. It must be his phone. It must be him that's doing it. They could have gotten to the source of it. They could have gotten the Gmail records for that account. They could have gotten Blue's Instagram account, literally HOP, House of Pain CEO. But they didn't. Some could say willful ignorance. I'm saying that it's Sergeant Smith, Detective Smith deciding. It doesn't matter. I'm committed on what it is. Now, there's anomalies within the cell communications. Now, they've never actually tied Hakeem Robinson to that 478-305-9583. Smith got up here and he tried to say, well, the IP address, the first four. He's not an expert. We heard from two other cell phone experts. They were never presented with that information. He tried to say, well, the provider told me, that's hearsay. The provider told me that, it's the first four, not the last four, but I subpoenaed the wrong one. It was a 7, it was a 1, but yeah, it could be. Now, the government tried to say that based on what he said, it's a link. His words, could be. But even that is not even close to a connection. They had an FBI cast member agent up on the stand, didn't ask him any of those questions. You best believe that if they tied the IP address of that phone to my client, you would have had an expert from T-Mobile sitting in here going, here's your link. But instead we had Smith get up there and go, yeah, it could be. They're trying to blur the line, trying to connect him to the shooter and the phone to Mr. Robinson. Now, Blue says that he was worried about his son. Given his testimony, I don't think he cares about his son at all. But he says, you know what, I cared about my son. Whether it's him caring or not, there is not a single phone call to that number. You would think that if this is the phone that is being used in the commission of the crime, that somebody would be repeatedly calling it. Now they'll get up here and say, well, it could be a FaceTime call. We have no record of it in a data event. Translation, they want you to speculate. They have never connected that phone over to the shooting. There are communications with one of the people much earlier, not during. There's a pin drop, could be in an area. They're wanting you to speculate. They need you to speculate because they have not made the connection. Remember, too, that they have the color-coded, they may show it to you here, that the red stands for that. They even want to connect it before they've connected it because the 478 number is in red, and so is my client's known 1595 number. They have it both in red. The interesting thing is that throughout the entire time of the commission of the crime, you see no red. It's everybody else. Now, there was mistakes and anomalies with respect to the cell communications. First, Natalie Gann, glaring mistake. The cast agent, 7259, 7529, they admit it was a mistake. It wasn't entered in correctly. Look, in other lines of work, could it be a scrivener's error? Oh, I thought you wanted it medium rare, not well done. In a murder trial, when you're trying to explain, to have a jury make a decision beyond a reasonable doubt, there's no mistakes. That was a mistake. And then we also have the anomalies with AT&T. And he said it. He goes, look, we can't, 95, I forget what the exact percentage was, but he's like, we don't use it because of the anomalies. But they still want you to trust some of the AT&T records. So, staying on the topic of the phones. Now, they brought up in the closing argument that Abdul Jr. had a phone that was registered to Darrell Watts, and that the 478 number was tied to Darrell Watts. What they're leaving out is that Ballou's main number was also registered to Darrell Watts. Now, they also brought up this exhibit. It's a nice picture of Ballou. He looks like he's, indecisive, not the felon that he is. And they said, he's not going to send a message to himself. His email is literally right there, as if you're not going to see it. It's insulting. From his number, 2370, which is under Darrell Watts, sending it to 9583, and Abdul Robinson 71 at Gmail. Abdul Robinson Sr., born in the 70s, definitely not my client's email. They showed you this photo and made the argument he'd never send it to himself, where literally it shows that he sent it to himself. Talk about the DNA and the fingerprints. We, of course, embrace there is DNA on a shirt. I think it may be out here, maybe over there. But with the white shirt. Doesn't prove that he ever wore it. We talked about it with the expert. If I were to take my client's handkerchief and wipe my brow, my DNA is going to be on it. And she also testified how that very easily could be the reason why there is a mixture, because they take a swab and they do the entire compartment, and that very much could explain, well, the T-shirt's sitting there, then we wipe everything, why there's a mixture and why it's so low. But we embrace that. His DNA is showing up on a shirt that's in the car and also on the dash. He was friends with these people. He rapped about the life that he lived. We are not denying that. He was around them. He knew them. He wasn't doing what they were doing, which is why he isn't covered in tattoos and bullet holes, because he's not living that life. Fingerprint, the music videos. So again, we embrace this, but none of that, and I don't need to go over it because I know you saw the testimony. that they both agreed objectively in their testimony, I cannot say he was ever inside of that vehicle. What we know is that his fingerprints are not in the vehicle, and there is not a 700 billion DNA reading of inside of the vehicle. There's a small mixture. The DNA expert got up there and said, yeah, it easily could have been transferred by the T-shirt. The reason why the government's probably arguing it is because they know jurors like DNA and fingerprints. No, it's like that silver bullet, but not here. This means all it proves is that he knows people that we already agree he knows. The other evidence shows that. So don't let them sway you with the idea of DNA and fingerprints. Same time too, we have Chifton Hogan. If their rationale of anybody whose DNA is found inside of the car, well, they must be involved. Chifton Hogan and Blue said, oh, yeah, that's a family member to some extent. Anything that supports our argument that if you know people, your DNA could show up inside of their vehicle. Talk about witnesses in this case. Latham, the expert. The government, and I said this before, they paid $80K, $70K, $80K, I don't know how much his expenses were flying back and forth and lodging, to come in here and say, yeah, maybe. Meanwhile, all of the witnesses consistently describe somebody that's short and skinny. Then they arrest a guy who's 6'2", 6'3", 230 pounds. That's not how the truth works. How desperation looks. Latham up on the stand, and I asked him, and I go, can you exclude me? Without scanning me? His answer is no. And from that you can take, there's nothing unique about what he's saying. He can confidently say, well, it's not Leroy Whitaker, it's not Dominique Barner, not being argued here. But nothing more. Now the government, in their argument, they have brought up this photo. Now we have to talk about Charles McCormick's height and weight. Latham said, well, they provided the information to me and I do the analysis. And what they gave me is that Charles McCormick was 5'10". There's a problem with that though, because I had to bring it out through the medical examiner. He goes, that's just an estimate. Post-mortem, there are differences. Could be 5'9", could be 5'11". Also, this person is wearing shoes. So when that was brought up with Latham, he goes, I was given 5'10". I then. They call the medical examiner, and the medical examiner tells you that's not, I can't say that's an accurate height. But they want to do this comparison in between somebody who's 5'10", and then over to the shooter. We know that Charles McCormick was 143 pounds. We know that definitively. When you compare that over to the person next to him, now, Charles McCormick is obviously turned a little bit, and they're not in the exact same posture, and I'm not denying that. But I could also make the argument that he's wearing darker clothes, which makes things look smaller, and the shooter is wearing light clothes, which make things look bigger. What you don't see is a huge difference, 100-pound difference between the two people. See two skinny guys. Also, as for the height, yes, they are moving, they're dropped down. Let's do some math here. Hakeem Robinson, let's give him an inch, we'll say 6'2". Shoes, that's another inch. So he's at 6'3". Add then 3 inches on top of the head under that hood. That person's pushing 6'5", 6'6". If that were Hakeem Robinson next to Charles McCormick, 5'9", whatever it is, he would be way taller. He's not. Again, the government's trying to shrink it. They're glossing over the 3 inches that Latham said, yeah, that could easily be 3 inches on top of his head. I submit to you it could be more. If Hakeem Robinson, little tiny feet, there's no escaping those little tiny feet. If you add an inch onto him, 6'2", 6'3", then whatever's underneath that head, that person is going to be a giant. You are not going to mistake that person for short and skinny, not a dozen times in a row. But they want to get up here and say, Charles McCormick, 5'10", despite what the witnesses said. Hakeem Robinson, 6 feet. They're tailoring their evidence because they know that the evidence itself, the facts, suck. Now, they may get up here and say, well, you know, we didn't need these witnesses. You cut a deal with violent felons and you don't need them? You cut a deal with Barner, who's a reliable hitman. You only get the reliable hitman term if you have killed. We know that in these cases there's nothing to establish him as a reliable. In Rothermill, they killed the wrong person, an innocent guy in a bike. On this one, he gets caught, but he's a reliable hitman. Sounds more like he's a serial killer. They may get up here and say, well, you know, we didn't need these witnesses. Our case was strong enough. Then why cut those deals? He could be out in a matter of years. Blue has a likelihood of being out in a matter of months. That's desperation. Don't let them get up here and say, well, we didn't need it. They did. That's why they cut reprehensible deals with violent criminals. There's an internal conflict with their testimony. Right? Now, they're felons. They're cooperating to get a deal. Let's put that aside for a second. So Barner gets up on the stand and says in the Rothermill case, implicating Blue on how he could have been charged with much more than accessory, provided items. Blue got up there and he denied. So which one's lying? It's not our job to prove it, it's theirs to prove, okay, well this one's lying, but that one's telling the truth. As it stands before you right now, you have no idea. Schrodinger's cat. You have no idea who is telling the truth. But they want to put them up. They want you to trust these people, that they're pillars of truth. Because they came to them in handcuffs. Don't trust Johnny Shipes or Blue's daughter, who have no motive, and if anything, reasons not to come forward and testify. Mr. Shipes, Mr. Shapiro, because of his business. Blue's daughter, because she's basically saying that her father's lying in front of the judge that will be sentencing him. They have no motive. But no. Trust the people that came to us in handcuffs. Trust the people that we have on a physical leash to tell the truth. And again, we set aside the fact that they are murderers and felons. Don't let them get up here and tell you. They're both telling the truth, that either of them are telling the truth when they didn't clear up that internal conflict in their own testimony. Now, Natalie Gann. They said in their closing argument, well, she had no motive. She absolutely did. You could see it on cross-examination. I could feel the breeze from her lashes fluttering at counsel table as she was getting cross-examined about the motive that she has. Now, it's not about what this government thinks. As they sit there and smirk at you. It's not about what they think. It's about what that witness thinks when she's sitting on the stand. She knows Dominique Barner has implicated me in this case. I don't want to get charged. I'm going to do whatever the government says. Oh, and her husband sitting in prison being prosecuted by their office. It's about what's in her mind and the reason why she would have to tailor her evidence. Now, the government says, well, she didn't have all the details. She's older. She's not like the men she dates. She's smart. She knows if she commits too much, it could actually cause a problem. Well, I don't remember what he was wearing. Because if she were to say the wrong thing, she's not usable. She hurts their case, potentially gets them mad, which is bad for her and her mind and her husband. The handguns. How would Barner know to say that the handgun was... Look, Barner is not... I'm not saying he's book smart, but he's definitely street smart. He knows that there was, okay, and look, he was sitting on his case. He was getting prosecuted for months, looking at discovery before he ever made the decision to flip. He was arrested on the home invasion robbery. He had a whole bunch of records, and we're going to come back to that, on how he could have done what he did. But why would he claim that gun? Well, he knows that there's 3 guns in the vehicle. All right, one of them was used to commit a murder. The other one is a big machine gun. Yeah, that one's mine. Gave him musical chairs. He had to claim one. 3 people in the car, 3 guns. That one's mine. I'm not saying that the government, and if it's ever come off like this, I want to make this clear. I'm not saying that the government sat down with these witnesses and said, we need you to say this. Not saying that. Never would. But what I am saying is that they gave an opportunity to some really dangerous people. Dominique Barner is resourceful. He went on the court's computer system to stalk his prey, created fake Instagram accounts to figure things out in locations. He has a discovery on his case. We know that the first thing that was collected by Sergeant Smith were my client's meta records. The very first thing. Florida's a discovery state. This guy wants the government to be happy with him. They gave him too much of an opportunity. Now, the argument that we make over the recording, look, and we won't say it, the government has a right to talk to their witnesses. They're doing the work they need to do. They're talking to their witnesses. That's not our problem. Our problem is that the first and the second time they spoke to him, we have no idea what happened. Now, again, I'm not saying that these prosecutors told him what to say, but I do have any concern when the government is doing things behind closed doors, our government, without an ability to see it. And when they spoke to Dominique Barner the second time, Sergeant Smith told us they were leading questions. If you're getting the truth out of somebody, you don't have to lead them. You were driving the car. Hakeem Robinson was in the car. They're giving an opportunity for somebody to say the facts that they know the government wants to hear. And that's a problem that I have, that they allowed him that opportunity. Somebody that they knew was dangerous. Look, that serial killer has no problem taking a life. He has no problem lying to save himself. Sadly, we have no recording of the initial meeting. We don't know how he was able to get his facts straight, but I do know meta records are in the possession of law enforcement months before he cooperates. Florida is a discovery state, and he gets up there in another one of those times where we get new testimony. Oh yeah, he called Raekwon. You can clearly see that in the records. But what the government won't embrace is that my client's regularly talking to Raekwon, somebody that he's supposedly supposed to have a problem with. What that proves is he doesn't have a problem with these people, which is why he doesn't have bullet holes in him, that he's not living that life, that he's not tatted up. And we also know it because after that, Raekwon Howard tried to kill people that we know were involved. Didn't go after the guy that he's talking to regularly and joking around with. So, it's very easy for somebody like Dominique Barner in a meeting. You know, Dominique's sitting there. Did Hakeem make any phone calls in the car? In the questions being asked by a prosecutor that's holding a stack of papers. Barner's smart enough to go, yeah. It's that simple, and it's that easy for that to evolve into, yeah, he was talking to, yeah. And that's ruling out the fact that he has the records. He was involved. He's going to get some of the facts correct. But he's also resourceful, again, on hunting his prey. This time, the prey was Hakeem Robinson. Now let's turn to Blue. Sat up here, fake tears, my son. Y'all saw it, there was no tears. He had that emotional pause. Yet he had no emotion when he was talking about the murder of his other son, Willie Addison. Abdul Robinson's daughter, no motive. If anything, reasons not to. I mean, of course, she doesn't want her brother wrongfully convicted. But she has reasons not to testify as well, too. Jonathan Shapiro, Johnny Shipes, no benefit, risk. Both of them gave a description of the height and the weight of Hakeem Robinson around that time. And it's inconsistent with what the government's saying. So, the government may get up here and talk about the fact that Barner and Blue are not sentenced yet. And that they don't know what they're going to get. That's by design. They got to make sure that they're dangling that carrot in front of them so that they do what they want them to do. It's also so that you as the jury don't hear what is potentially an offensive sentence that they get because of their recommendation. They want you to think, well, they could get life. There's no reason why they couldn't have been sentenced before coming in here. Now, one thing I want to go back on that I did miss. It's a really big point. And it's that both of them said, in government, I invite you to get up here and explain this one, that both of them said, Dominique Barner and Abdul Robinson Sr. have to say queso to get the deal. Those are their words. I have to say queso to get the deal. Let's talk about the jury instructions for a minute. I'm almost done here. So, when you go back into the jury room, one of the instructions you're going to get is weighing the evidence. And this is an opportunity for you to evaluate a witness's testimony. And these are things that the law in Florida says you got to be cautious of. We need to point this out to you because this could lead to a miscarriage of justice. Did the witness have some interest in how the case should be decided? And they're not spending life in prison. They're not getting prosecuted on multiple cases. Does the witness's testimony agree with the other testimony and other evidence in the case? I submit to you it doesn't. There's not massive conflicts, but there's definitely irreconcilable conflicts between their testimony. Has the witness been offered or received any money? We've already talked about Latham. Preferred treatment or other benefit in order to get the witness to testify. We are going to charge you with principle to murder. You're looking at life. You're a convicted felon 2 times prior. If you say what we want you to say, we'll recommend 72 months. Has any pressure or threat been used against a witness that affected the truth of the witness's testimony? You'll go out in 72 months, but you got to say case or otherwise you're looking at principle to murder. Did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Yes. Has the witness been convicted of a felony? Both of them, yes. Just one of these is enough. They're hitting almost all of them. They're not just felons. They're not just convicted felons. They're felons who traded a story for a deal to save themselves. They sat down with the state and told them what they wanted to hear, not because it was the truth, but because it was the price of their freedom. It's not justice. It's bargaining with guilt. The government wants you to trust them over all of the other objective, unbiased, unmotivated witnesses. That's scary. You know, the government, they may get up here and talk to you about reasonable doubt and say, you know, look, my job is I got to get you in a boat across this river. There could be holes in the boat, but I got to get you across the river. Now, I want to change and use that example, instead talk about waiver and vacillate, because that's what reasonable doubt is. You're standing there on the shore. You're looking at the boat. The boat got some holes, some water's coming in. You're told that there are anomalies with the boat. It was manufactured incorrectly and there's problems. Any reasonable person's going to be sitting there going, I don't know. That's waver and vacillate. But add on top of that, the two people that are captaining the boat are violent felons, and they're telling you, hey, this boat's fine. No reasonable person's getting into that boat, and that's what they're asking you to do. Let's talk about their burden. Their burden of proof. I'm not going to go through this or spend much time on it, but just for the illustration of what we're talking about beyond a reasonable doubt. Everything else below that, strong belief, guilt likely, probably guilty, possibly guilty, none of that is enough for them to carry their burden. They have got to be able to rule out every other possibility. But the case that they presented to you, there's a whole bunch of other reasonable ones.
All right. The jury will listen to the instructions as I provide them to you, but you may proceed with argument.
They can't carry that burden. They have too many holes in their case, which is why they're not embracing the actual facts of the case and instead trying to mislead you. Now, whomever from the government gets up here and does the rebuttal may try to sway you with emotion, show you photos of Charles McCormick, talk about the tragedy. So let me save them that time and do it here for you. What happened to Charles McCormick, what happened to his family was tragic. No parent should have to bury a child. It's horrible. Convicting the wrong person doesn't fix that. It makes sure that the person that actually committed it, or other persons, go free. It doesn't protect us here in Duval County. Hakeem Robinson deserves better. The people of Duval County deserve better than Detective Smith getting up there going, yeah, that post is enough. The McCormick family deserves better than that. The emotion of this, the understandable emotion of this case, though, there's no place here. That's an attempt potentially to sway you into a verdict because the facts aren't enough to do it. So I'll save them that time of making that argument. A short amount of time, you're going to be back in the jury room, you're going to be deliberating. You're going to be asked to make a determination whether Hakeem Robinson is guilty or not. Again, to quote his daughter, hell no. Thank you.
All right, ladies and gentlemen, I'm going to give you a short bio break since we've been going for over an hour. So I'd ask that you leave your notepads behind, have a step into your jury room, and then we will return with the state's rebuttal and the court's instructions on the law. Thank you very much. take your seats. At this time, I'll call upon the state for its rebuttal close.
May it please the court.
Yes.
Counsel. Ladies and gentlemen of the jury. I am going to show you the last photograph taken of Charles McCormick. I am showing you this photograph because that's what this trial is all about. It's about seeking justice for those brutally murdered. Okay. I show you this picture not to inflame your passions and make it so you find somebody guilty. I do it to specifically rebut a comment the defense counsel made. Before we go into that offensive comment, I want to say this.
Objection to integration of counsel.
Overruled.
What I am commenting about the defense, I wholeheartedly believe in the Sixth Amendment of the United States Constitution and Mr. Robinson's right to have all the witnesses against him cross-examined by a zealous advocate. And that is what we give. My criticism is not that they have tried to do their job. My criticism is that the defense stood up here after the young black man investigated by a black detective tried to imply that this case is somehow about race. Somehow country singers or hard rockers don't get investigated, that only young black men that do rap songs do. That's not true. Detective Smith poured out his life into this case for hundreds and hundreds of hours. And he didn't do it because of the race of the victim. He didn't do it because of the race of the defendant. He did it because Lady Justice is blonde. This courtroom doesn't consider those things. This courtroom says that that bias cannot come into your decision-making. Judge Salvador will tell you as such. This is about whether or not the state has proven its charge beyond the exclusion of every reasonable doubt. And we embrace that burden. It is not about young black men that rap, somehow us taking it out on them. Charles McCormick. You're going to hear a common theme throughout my rebuttal argument. Hakeem Robinson is either the unluckiest man who has ever lived on the face of the earth, or he's just plain guilty. The vast majority of the defense closing argument is about how an incredibly lucky piece of evidence, the dash cam video, somehow implicates that we have the wrong guy. That's been their defense since day one. Countless parts of his closing argument are about that. January 4th, January 14th, January 15th. It's not just about hairstyle underneath the hood. He screams over and over and over again, 6'3", 230. And then we have the photographs that show it's just not true. It's just not true. We have digital laser scans that say it's 6'1 1/4. before, a couple days after, wearing identical, I see what it is. The evidence proves that's the same sweatsuit. Tell just from that picture? No. But it's a pretty dang good piece of evidence. In the video, God bless, dash cams, surveillance videos, DNA. I've been doing this long enough that I remember when we didn't have all those things. And it's made our job a heck of a lot easier. And more importantly, it's made your job a heck of a lot easier. Because artful defense attorneys pounding their fist on tables, which they should do for their client, all of that doesn't change that a picture can tell us 1,000 words. In this case, it tells us one. You're talking about slender, these poor witnesses. Okay, challenge number one from the defense. Get up here and explain why you didn't call witnesses that were working out in Bailey's and looking through glass. He said, he said there's clean and dirty windows. Was Mr. Williams looking through a clean Bally's window or a dirty Bally's window when he was half the football field away with a guy crouching down? That his testimony to you doesn't help you make this decision because we have a video. The descriptions are totally irrelevant in this case. Again. They stand up here and argue. How dare we pay $70,000 to $90,000 for a paid extra? We're just buying our conviction. You know who deserved that? Hakeem Robinson deserved the state of Florida to spend tens of thousands of dollars to figure out if all these descriptions, and mind you, they're not all. People that are closest put it right on more better descriptions. And when you look at the photographs of him at the time, he's much smaller than he is now. But regardless, we wanted to invest that money. The defense attorney gets up here and glares about how concerned he is with the government. Know that your government spent your money to make sure that all the corroborative evidence was right. That we could exclude Barner and Whitaker from that video. By the way, they match the description that everyone gives. We're going to put so much stock into these kids. They match it. And we invested that money to see. He's never going to be, no expert's going to be able to look at those and say they identify a particular human being. Does the body morphology? He says there's no way these two guys that match the description of the shooter given by people who admittedly don't know and are guessing at someone crouching after they watch a shooting for 2 seconds. Deserved that money. Deserved every penny of it. We give that to you so you can have confidence. All the other evidence. Oh, little something. Talk about it's actually, it's been a long time. Cross-examining the medical examiner. Arguing about 5'9", 5'11". The doctor, in his report, in his measurement, says the victim, Charles McCormick, by the way, that's his address where all their cell phones are taken. It's 5'10". Driver's license says it, medical officer says it, and the video shows that the shooter was bigger, wider, and taller. I wouldn't call it an insignificant amount, which perfectly matches the way Hakeem Robinson looked the day before. weeks before. Remember, this is the defendant next to Leroy Whitaker. You've had the opportunity to see them. Not a huge difference, is there? And we know that Leroy Whitaker is smaller than the victim. 3 minutes or so, we heard about it. The video proves our case. Now, of course, no one's asking you to look at that video and find the defendant guilty beyond a reasonable doubt. We're giving you so much more. A couple rules that Mr. Robinson or any aspiring young rapper should live by. If you're gonna brag or post about killing somebody, you probably shouldn't have DNA in the murder car or a fingerprint on a gun left behind in the murder car. If you're gonna post hoodie pictures of yourself singing and rapping in the weeks and months before and after, you probably shouldn't wear the black and tan hoodie to commit the murder. If you're gonna have a burner phone, you probably shouldn't take selfies on it. If you're gonna stake out a victim, you probably shouldn't get distracted and let him leave his apartment complex, so you have to follow him to a Merrill Road strip center where police officers are hanging out. And if you're going to pick co-defendants to do the case with, you probably should have done it alone. If you're going to get picked up by the girlfriend of one of your buddies, you probably should hope that she's ride or die. That she's not going to come to this court with no intimidation, with no cases hanging over her at the time she gave her sworn statement and here today, and say, that's who I picked up. And just for a second, before you think, well, maybe Hakeem Robinson, he's too smart to do that. Whoever did this killing, it includes Whitaker and Barner, they decided to go in broad daylight in a neighborhood, jump out and run through a strip mall, execute a human being for the whole world to see. The actions of a 21-year-old that gets excited and angry because he sees a person that has so disrespected his brother. Has dared utter these words.
Smoking on Whitley, Parker screaming out for help. Headshot instantly.
Put it in your blood. Should we be smoking on Willie? Picture to the left, rest in peace, brother, is posted less than 24 hours after the defendant took care of the person that spoke on Willie. There are very few people in the world, not exclusively this defendant. We've arrested a lot of them. A lot of them are charged, not all. A lot of them are charged. And there are others out there, but there aren't that many in ATK that had a motive to kill 6-block Lil Buck. The greatest motive was Abdul Jr. Both defendants, Leroy Whitaker, and mind you, we tried these two cases together. All the evidence against Whitaker corroborates what Barner says, what the entire investigation leads to, and all of that evidence helps prove Robinson while you're not deciding Whitaker's case, you're going to have to know some of that evidence to know why Hakeem Robinson is guilty. And some of that is the phone records. So we have the opportunity by both defendants. Farmers admitted it. The opportunity by both defendants. Either the cell site was off or it puts them there. The defendant, by the defense's own admission, his known cell phone, now, 21 years old, trying to get the times right. He has his cell phone powered off for the exact amount of time it takes to do this case, to do this crime. And his cousin and friend, overwhelming evidence, also overwhelming on him, when they're doing this crime, it just happens to be powered off. And the defense, I submit to you, was trying to show that the data on the phone, because you see there it's data, and this is the situation where the FBI analyst was unwilling to map the data sessions. Between those two times, nothing going on while his phone's turned up. Remember the cross-examination of the expert over and over again? He was on a boat. He was, no, your smartphone is on. It's getting data. Even if it's not connecting to a tower, it'll show data usage. Said that. They kind of followed it. But when we plotted the data usage, which the FBI was unwilling to do on their own because of the errors, 95% accurate, I think 95 to 98% accurate. You know what that data usage, so this is when we did the Google Maps stuff, and we put in the coordinates. When we did that, his known phone, his admitted phone, was in two really important places before it got powered down. Remember those Google Earth pictures? It was one picking up Barner off of University, Spring Park. You saw that map. Then it was off Atlantic Boulevard, which is exactly what Dominic Barner said they went to pick up the Impala. Excuse me, the Nissan, to commit this crime. In an apartment complex off Atlantic Boulevard. His phone, known phone, is in those two locations, just like Barner said. And those were never mapped. Barner couldn't have been fed the information by the state. He did that in a court live. Lo and behold, just like he said, like Barner said. So the other phone records show that you can see the red is going to be Mr. Robinson's burner phone, the phone that he takes selfies on, that Hakeem Robinson got in his dead friend's name that he handed him, that existed for about 2 months. On this particular occasion, Mr. Robinson thought that burner phone would never be tied to him because his real phone was turned off. And by the way, the whole selfie thing, and he never said, dads don't call their sons on their burner phones. Dads call their sons on their real phones. The burner phone is when you do dirt. So, he's hitting off the Merrill Road Tower shortly before the crime. The arrow points that he is going in the vicinity of Townsend Boulevard. This is you see the arrows, the red arrows, and then the 7201 Arlington. And the defendant's burner phone is going in those directions, and you can see the data usage in the green box to the right of all the little arrows. Is going in the direction of where he is picked up. This is his burner phone. His real phone is turned off. And then we find that it's going in the right direction. We find the cache. He deleted all this, by the way, but this was found in the cache. He didn't know about that. Off the burner phone cloud, the phone's gone. On the burner phone cloud, we find the pin drop in the location of the nature preserve. You kind of see it cut off, the nature preserve, the tree hill on the right side. That is just, I don't know, maybe 100 yards, Lillian Road, Lone Star. That's just a little bit north of where he was picked up by Natalie Gann. Not the exact location, it's just a little bit north. We have the path he came through the tree hill. On nature preserve, where we're not at Boston, identified a person in a black and tan sweatsuit. Just the unluckiest man on the face of the earth. Identifies a black and tan sweatsuit coming out of the woods. I think he's a nature lover. And then Natalie Gann picks him up. Says a white girl carrying a phone. Mention the IP address. The defense makes a big deal about Smith not being an expert because the IP address helps prove that the burner phone is Hakeem Robinson's burner phone because of the IP address. The T-Mobile records, some of which you'll have in there, if you care to look at it, actually in some of the instructions, not all, but in some of the instructions in the records, the top line says the IP address, only the first four numbers should be considered. Now, the records that we have introduced in this case tell you it's just the first four numbers, not just Smith. That's just a side note. So we have them all together, meaning back safe on Brown Jersey Court, Hakeem, Kareem, and Barner, and Whitaker. Look at that. And this is, magically, the defendant's real phone turns back on. And they're safe. Objective known truths. We know the Nissan is the murder car. We know the shooter fled with the murder weapon. Described perfectly. There is no murder weapon in the car. The murderer fled with the murder weapon. We know this as an absolute fact. Robinson is linked to the murder car in 3 different ways. Shirt, the driver's compartment swab, and the print on the firearm. Here's where the defendant, mind you, they spent 2 minutes talking about the DNA because it's not good for their case. I get it. But here's where their argument about transfer fails. Look at the way that shirt is. Hold on. Think back to what the DNA analyst said. I took swabs of the wearer, the neck, and the underarm. Not just in the middle of the shirt that's balled up in between the seat. Somehow, their argument is that this balled up shirt, wrapped up shirt that has wearer DNA of the defendant, oh, by the way, and Leroy Whitaker, of the defendant, somehow that jumped off of the shirt and got in the driver's compartment and is balled up in the corner of the seat. Maybe he's the unluckiest person on the face of the earth. Maybe he's just guilty. Oh, and his print's on the slide of the firearm. It's right next to the shirt that has his and Leroy Whitaker's DNA. Maybe you shouldn't be bragging about killing Willie with that evidence. I mean, killing Willie's killer. I bragged about killing Willie. Incredibly powerful evidence. No chance that could be tampered with. Remember, they sealed the vehicle. It's the way it was when all 3 of them jumped out because they decided to commit a murder right in front of the police. And we were able to catch them. Whitaker's in the car 2 ways. He's on both shirts. We have those shirts. Robinson possessed a similar and unique firearm before the crime. This was kind of just glossed over. But we did pay a lot of money addition to this defendant deserving that, digital expert Latham provided another service. Firearm in this defendant's hand just a few weeks before this murder. And he is celebrating it on the Bang It Up music video. Is the same type of firearm. And according to Barner's testimony, is the same one. We hear from the FDLE firearms expert, Emily Amahir, right woman. The first FDLE person called. The manufacturer of that firearm discontinued. And although there are other models like it, there aren't that many of them. This isn't a Glock 9mm. This isn't some common firearm that everyone in the world has. This is a relatively, I don't want to oversell it, I'm sure there's guns out there. This is a relatively unique firearm.
Objection, Your Honor. Mischaracterization of the testimony.
Overruled.
You rely upon what the expert, Ms. Amher, said. No longer manufacture that kind of gun. Companies go out of business. It's usually because you don't sell a lot of the gun. Sell a lot of the gun, you usually keep making them. Right? AR-15 is real popular. Keep selling them. Okay. Enough on that. Barner and Whitaker were so desperate to get away that they assaulted Miss Buckley and left their DNA on her pajamas. Again, it shows that they were all in for a penny, in for a pound. And that proof corroborates Barner, corroborates Blue, who picked up these two guys after they assaulted Miss Buckley. And you heard all that testimony. And the buttons here and not here. Whitaker and Barner got picked up by Blue. We know that that's a fact. And they've pled. These are objective truths. You don't need to assess credibility. Robinson is right-handed. Fact. Shooter was, guess what? Right-handed. Not prove he did it? No, but it's a nice fact to know, isn't it? He has worn a black and gray hoodie just like the shooter has worn. When you combine all of these things, you are narrowing the scope beyond just the exclusion of every reason. We are not eliminating every conceivable possibility. We are not eliminating all of them. I submit to you we have. But the proof here is beyond to the exclusion of every logical, well-founded, reasonable doubt that any logical person could have about whether we got the right guy. Robinson was real happy about defense wants you to think that he's arrested because of this post. Sergeant Smith has his fingerprint on a pistol in the driver's seat console, in between the seat and the console. Water. His print on the slide.
Okay.
In between the seat and the console. He has his print. And that's the post he sees. It's context. You know, they said, we're going to explain the context of all that. That's the context. Context is, Smith goes, holy cow, the guy's bragging about it. The kind of person that would brag about this is the same person that would go out, narrow road, at 10:58, and gun down another human being in front of everyone in the world and the dash cam to see. Same type of person. The video proves the descriptions were wrong. Proves it. We called the witnesses that were able to provide meaningful testimony, not the witnesses that were working out on the elliptical looking through glass. For them to say, I guessed, none of them were sure, I guessed about the person, and the video proves me wrong. Spent a little bit of time talking about Barner. He is a murderer. I don't like him. Vince has a good time. He got beat up twice by two very seasoned, experienced defense lawyers. It's hard to sit there and listen to them beat him up. Fine. We expected that. Because he deserves it. Reprehensible deal. They turned around and screamed at the state of Florida. We got a convicted murderer to subject himself willingly his own freedom. Have Judge Salvador sentence him to life without the possibility of parole. The only benefit that we gave him is you get to testify, show your remorse, stare at the face of your community, of your friend, and do what's right for Charles McCormick. If you do that, the judge can consider it anything she wants, including giving you life. For 50, 45 years. He knows that. There's nothing he can do about it. I wish all prosecutors were that unsuccessful in convicting murderers. Lou is looking at 20 years. He's a middle-aged, 50-something-year-old guy, 55 I think he is, with diabetes and kidney failure. Not very different from the deal worked out for Barner. All witnesses meet. It is entirely proper for witnesses to meet with us. The defense wants to say, well, I'm not going to argue they shouldn't meet with their witnesses, but they shouldn't meet with their witnesses unrecorded. Scenario. Dominique Barner, you're going to plead guilty and subject yourself to life. The lawyer is here. We need to make sure this is something that you really want to do, because once you give this sworn statement, there's no going back, because you're going to be under oath. We're going to sit down and make sure that this is something that you're going to be willing to do before we go on the record. You're staring at your friends, your community, your family, and you're turning into the one thing that you swore you would never be. Snitch. Are you sure you want to do this? Yeah? Is this what you're going to testify to? Yeah? All right, we're on the record and we're putting you under oath. Oh, how dare the government do this? A pre-meeting is somehow evil? This is what they're arguing. No witness should be discredited for talking to a lawyer about his or her testimony. Barner wants the absolute best deal for himself. No doubt about that. He said it over and over again. So his plan, according to the defense, is to lie to the people who will recommend a sentence to the judge and lie in front of the judge that's going to sentence him. What if over years and years we find out that he's lying to us about the facts of the case? Remember the DNA evidence didn't come back? It was until mid-2022. All that cell phone, all that Instagram, that stuff's just pouring in. And we're going through it up until shortly before trial we're pouring through. And somehow he's going to make the decision, I'm going to subject myself to life, knowing she can give me life, knowing the state will make a recommendation. I'm going to lie to these people about who's with me? The defense challenged me to say, why on earth did they say that part of the deal was I had to implicate my son or my good friend? And they said, yeah, if I say it's somebody else, the deal's not there. Because it's the truth. And if they say somebody else besides the person that did it, then of course there's no deal. Because they're committing perjury. The evidence doesn't show anybody else. The one little piece of evidence that shows somebody else, sort of, is this Chris guy whose hair, not skin cells or blood or anything like that, whose hair, which is much more easily transferable, and he lived and hung out with the people living in that Brown Jersey courthouse. I don't know if he lived there, but he certainly was there. The testimony from Abdul Robinson was he was there all the time, and his baby mama lived there. But he was there all the time, and that little piece of hair was there. So what did the detective do? Pull his cell phone records. Let's see where this guy is, even though there's no implication he's an ATK or any of that stuff, or has any motive to do any of this. But they go pull it, and he's across town. You know, one of the jurors said in jury selection, trust but verify. And that is exactly what you have seen here today. You don't have to trust every word Dominique Barner says unless you verify it. Even the defense had to admit. If you caught me smirking, it was when I heard this. The defense had to admit that Barner got his facts straight. Yeah, he did. He get his facts straight. Trust, but verify. Barner had no idea the person he said that picked him up was going to testify and agree to that. He didn't know that when he gave his sworn statement. How was he supposed to know that? Barner doesn't know that Natalie Gatton and Nada Boston were here to testify. I need to reset here because the video evidence that we had in our first slide that shows how the defendant looked leading up to this crime, combined with him wearing the sweatsuit and then the picture of the shooter. That piece of evidence, combined with Renata Boston and Natalie Gatton, you don't need DNA, you don't need Barner. That evidence in and of itself is enough to convince any reasonable jury that you got it right. So when you combine all the pieces of evidence, we have a guy in a black and tan hoodie murdering Charles McCormick, running into the murder car, jumping out of the murder car with the same gun, running and jumping fences. And by the way, thanks for the video when you toggled. Come on, talk about that much more. I appreciate it. We did it. We did it. It certainly seems like the police officer is a little bit taller than the shooter. Anyway, jumping fences, doing all those things. One more thing about sprinting. You see the video. We played a little bit of it. And God bless police officers who chase after gunfire. They have to put on a bulletproof vest to go to work. But he was coming out of Publix off duty. Whole body cam thing. He's not prepared to work that day. He's off duty. He didn't have the body cam.
The testimony, he was on duty.
Overruled.
That's besides the point. You remember, it's not mine anyway. Does it really matter? That he was so cautious when he was looking for me to walk by that car. He didn't sprinted by that car. Officer Collins walked kind of slowly, looking around because he knows, he said it, someone could be sitting there ready to ambush him if you saw that guy with a rifle. You don't be chasing after him full bore. That's idiotic. That's how it got away. Out of Boston says, after I get a text alert, it takes a long time to get where the defendant got all the way through that woods to get rid of the burner phone and the rifle. Get rid of those things. He comes out of the woods wearing a hoodie by himself. She goes, I'm getting out of here. I did notice a girl, white girl with a phone. Let's be very, very clear about this. Natalie Gatton, amen, sworn statement. She was a free woman. Everyone she loved and cared about. Her husband subsequently is irrelevant. She'd already given her sworn statement. These are not people, as the defense characterizes, coming in chains by the state's leash. All the eyelash comments the defense can make about her doesn't change the fact that she was a rock on that witness stand. She said, I used to date Torgon. I know all these guys. They weren't going to go up there and pick this guy up. They told me, the white girl, pick up this guy. I don't know if you pick up. If we're trying to strong arm her to testify, why doesn't she say he was wearing a black and tan hoodie? As opposed to the truth, which is, I don't remember what he was wearing, but it was Hakeem. That's where the not a Boston combination with Natalie Gant is proof beyond a reasonable doubt. That's the identity of the person executing Charles. Forget the DNA, forget the prints, forget the brand, forget Barney, forget Blue. Combine it all. That's where you get beyond a reasonable doubt. You have that abiding conviction of guilt. You can be confident in your verdict. And that's where we get beyond all possible doubt. Dominic Barner may be a liar. He's not lying. He couldn't know the digital expert Latham was going to analyze the body morphology and conclude the defendant could be the person behind the mask. Now, how did he know that? No idea. And by the way, you have to combine that with the knowledge Dominic Barner has given his life over to Judge Salvador in the state of Florida as the defense capacity. He's given his life over to us. He better be right when he tells us who did this. Because the body morphology will prove it. Fine. You won. Barner had no idea that we would be able to link Whitaker's phone on Instagram. That Instagram for Whitaker is the verification number on his Instagram records. And when he on Instagram says, "This is my phone number," ding, 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 we were able to link it to Whitaker. They don't, it's not registered to him, but he says, "This is my number" on Instagram. And it proves, that phone proves the location every single step of the way that Whitaker is at with Barner. Step in for a penny, in for a pound. And Barner had no idea that the cloud would capture proof of Robinson's burner phone was his, and they could link him to the murder. He had no idea of he couldn't fabricate the DNA and print evidence. He did not know that Robinson's known cell phone was turned off during the murder, and that the phone data of the known phone would be getting off his apartment and the pickup for the Nissan. Well, how does he know that? Look how street smart you are. It's going to be hard for y'all. It was hard for us. Mr. Cooper and Mr. Atkinson are much better at it than I am. I struggle with this stuff. And Dominic Barner's going to do it? It just means he's telling the truth. That's all it means. The defense challenged the state on a number of different things, and each and every one of those we have easily rebutted. Out of Boston never said shoulder length dreads. She said dreads to the chin, which if it's sticking out of a hoodie, that's about where it is. Defense argues things like, "I'm not saying that Chris Brown did it." Look at the video, you'll see the defendant's hand. You'll see Hakeem Robinson's hand and compare that to his complexion. It's the same. Not to mention all the body types. There's no DNA transfer. The defendant was in that car, jumped over the center console, which is where his touch DNA came from, and the shirts and the guns that he'd already handled, jumped out and was so excited he didn't wait for his backup. 700 billion to 1 chance that someone other than the defendant is on that shirt. 4.4 million to 1 chance that this defendant's touch DNA is on the driver's area. He's either the unluckiest man on the face of the earth, just plain. No matter how many times you pound on the table, scream 6'3", 230, have the video evidence to prove it's just not true. And then, once you know you have that abiding conviction of guilt, the job is yours to find the truth in this case. The dead, they can't call out for justice. It's up to us, the living, to seek it on their behalf. Nothing that we do here change the lives of that poor family. He will be dead forever. And the last known photograph of him will be on the slab in the medical examiner's office. But what your verdict can do is forever define Hakeem Ksoo Robinson is the man behind the mask. Proven to you 700 billion ways. Trust that you will uphold your duty to find this defendant.
All right, thank you, Mr. Mizrahi. All right, members of the jury, you have now heard and seen all the evidence which will be introduced in this case, and you have now listened carefully to the arguments of the attorneys. And I'm now going to direct your attention to the jury instructions, which I'm required to give you, which I remind you, you are required to follow. For your convenience, the jury instructions are going to appear on the monitors before you so that you can easily follow along as I read them to you. In addition, I'm going to be sending in one hard copy of the instructions to the jury room for your use during deliberations. So let's make sure that your monitors are on and working. Yes? All right, very good. All right, let us begin. And I would ask any members of the gallery, if you wish to leave now, you may do so, but once the instructions begin, I don't want people coming in or out, that would cause a distraction, excuse me. All right, thank you. All right, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Hakeem Robinson has been accused of the crime of murder in the first degree. In this case, Hakeem Robinson has been accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. I now instruct you on the circumstances that must be proved before Hakeem Robinson may be found guilty of murder in the first degree or any lesser included crime. As to count one, to prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Charles McCormick Jr. is dead. Number two, the death was caused by the criminal act of Hakeem Robinson. Number three, there was a premeditated killing of Charles McCormick Jr. by Hakeem Robinson. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. As to count 1, to prove the lesser included crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Charles McCormick Jr. is dead. Number 2, the death was caused by the criminal act of Hakeem Robinson. Number 3, there was an unlawful killing of Charles McCormick Jr. by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and number 2, is done from ill will, hatred, spite, or an evil intent. And number 3 is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. As to count 1, to prove the lesser included crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Charles McCormick Jr. is dead. Number 2, Hakeem Robinson intentionally committed an act or acts that caused the death of Charles McCormick Jr. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. The state must prove the crime was committed on January 15 of 2020. It must be proved only to a reasonable certainty that the alleged crime was committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness's testimony agree with the other testimony and other evidence in the case? Number six, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number seven, has any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number eight, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Number nine, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or has been promised immunity from prosecution or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Now, these are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Number 8, your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Now, during this trial, I have permitted you to take notes. You will be allowed to take those notes into the jury room during deliberations. You are instructed that your notes are a tool to aid your individual memory. You should not compare your notes with the notes of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. They are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And it will be on the screen, but I'm also holding in my hand the one-page verdict that is styled State of Florida versus Hakeem Robinson, titled Verdict Count 1. You have 4 verdict options, and they read as follows. The first one is, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. If that is your unanimous verdict, you mark that line with an X or a check. The second verdict option reads, we, the jury, find the defendant guilty of second-degree murder, a lesser included offense. If that is your unanimous verdict, you mark that line. The third option reads, we, the jury, find the defendant guilty of manslaughter, a lesser included offense. If that is your unanimous verdict, you would mark that line. And we, the jury, find the defendant not guilty. If that is your unanimous verdict, you would mark that line. So say we all, done at Jacksonville, Duval County, Florida, and there's a line for the foreperson to sign and date the verdict form. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring that verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or any electronic communications such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. And if you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, either in writing or orally here in open court. Now, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. So, ladies and gentlemen, that will conclude the instructions. At this time, I will allow you to take your notes, 1 hard copy of these instructions, the verdict form, and all of the exhibits into evidence back into the jury room for you all to begin your deliberations. And as we discussed yesterday, this will be a working lunch. Of course, you can eat lunch in the jury room. And that will be all of you, with the exception of jurors number 13 and 14. I don't know, ladies, if you all knew that you were the alternates in this case. We generally don't share that information with our jurors prior to this point, but that means you will not be deliberating with the rest of the jurors in this matter. Now, before I excuse you, do you have any personal items that you need to retrieve from the jury room? Okay, if you both could quickly go with the bailiff to retrieve those things, come back out here as I'll have some final parting instructions for you. And the rest of you, ladies and gentlemen, if you don't mind just patiently waiting until they return. You may go now. Kim, you staple that for me. All right, you all may have a seat. And so, ladies and gentlemen, while we wait for the alternates to come, just some other tips or instructions. As you've seen in the jury room, there's a large television, smart television, and that's the device you would use to either watch any videos or hear any calls with discs that have been moved into evidence. Should you experience any IT difficulties, we are not expecting that you will, but should there be any technological issues with the use of that device, you can please ring your buzzer and send a note through the bailiff, and we will be sure to get whatever issues fixed. But otherwise, you can take your notes. We will transfer in all of the exhibits into the jury room, and then you may begin your deliberations. We'll just await the return of the 2 alternates. All right, thank you. All right, ladies, if you don't mind just standing here to the side so we can let the jurors leave, and then I'll just have some final instructions for you. At this time, ladies and gentlemen of the jury, you may now retire to the jury room to deliberate your verdict. All right, the jury's out of the courtroom. Ladies, I want to thank you so much for your time, your attention, your service during these 2 weeks of trial, I'm sorry, I need to look at y'all. Let them close the door. I know this has been a huge ask. That we make of our jurors, that we make of our community members, and I hope you don't feel like your time has been wasted. Alternates play a very important role, and we oftentimes have to use them in the deliberation of cases because we, especially on multi-day or multi-week trials such as this one, we lose members of the jury for a variety of reasons. Illness, health, emergencies. I mean, as you can see during the course of this case, we've lost some members from both panels for a variety of reasons. And so when that happens, if we did not have alternates, we would not be able to proceed with the case and there would have to be a mistrial declared. So it is a very important role you serve, and I do sincerely and genuinely thank you for your service. At this point, I will tell you all of my prior admonitions and prohibitions about talking about the case with anyone or looking things up or watching on the news. Those are all lifted. You are free to do those things if you wish. Absolutely no prohibitions against that. I will also tell you that you might be questioned by folks who are simply curious about your thoughts and opinions on the case, by the media, by the attorneys, by anyone. And so the decision about whether or not to maintain your privacy, of course, is yours. You do not have to speak to anyone. Of course, you're free to do so if you wish, but otherwise you are free to leave and not to speak to anyone here. Now, if you want to stay to see what the verdict might be, or if you want to leave but still know what the verdict might be, we have your number. We can certainly call you and let you know. But at this juncture, ladies, with the court's sincerest thanks and appreciation, you are now excused and free to go. All right, thank you. Yeah, you can send everything. Except the live rounds. All right, the alternates have left the courtroom. Any exceptions or objections to the jury instructions?
Not by the defense.
Okay. I will let you all know that I've received word that the Whitaker jury has reached a verdict. That happened at approximately 11:42. Obviously, they needed to wait until this part of the trial finished. So it is now 12:27. Just need the door to close. Okay. So with that, I'm happy to hear from the state or the defense for Mr. Whitaker what you all want to do. I know you briefly discussed sealing it yesterday. I don't know if that is necessary at this juncture. I don't necessarily want to keep them here waiting for hours. Okay. Yep.
Obviously, the reaches a point where they can't stay anymore. So that's the only concern. I think we've given the jury the case early enough to have some level of confidence that that's not going to happen. And certainly, if it does, the worst case scenario happens, stronger admonitions about lack of contact.
Okay.
That is a concern. We discussed it yesterday. I'm not really sure what to do. I understand not keeping them for 6 hours, twiddling their thumbs.
Right. And obviously, Mr. Robinson's jury just went out here at 12:24, so we still have a good chunk of the day left. So that does give me also some confidence. If it's 8 p.m. and they haven't reached a verdict, or 9 p.m. and they haven't reached a verdict, then I suppose we can address what to do at that juncture. But otherwise, Ms. Schlax, any issue with my releasing the verdict at this time? And why is that? Okay, I understand the request. Also, quite frankly, I will say, rather, since this case has generated a lot of interest and we have had full and crowded courtrooms, doing 2 verdicts at once might pose some issues that maybe wouldn't be present if we did them separately. So that's another reason that I think my preference, unless I hear strong legal basis or arguments otherwise, is that we're going to receive Mr. Whitaker's verdict now.
Your Honor, my concerns are I don't know how insulated that room is, if anything is heard. The other suggestion, the thought that popped into my mind, we release the Whitaker jury as if they had gone a full day and still needed it and call them back at a point in time to read the verdict.
But I wouldn't know at what point in time, and then trying to get them back from different parts around Jacksonville, that doesn't seem doable. And in terms of them hearing, usually it's Madam Clerk who publishes it. She does not have to speak into the microphone, and I'm pretty confident that it would not be heard in there.
Can we put them in that other jury room?
Well, they're in that jury room now.
I'm saying that once they're brought in, to put that jury into that jury room. Again,
Yeah, that would be a telltale sign that that jury has reached a verdict and they're not there anymore. So,
as long, if it's 100% that they wouldn't hear anything.
yeah, we don't have to speak into the microphones. We can announce it right here.
Is there another courtroom where it could be read?
I mean, we have lots of courtrooms in this courthouse. I don't know if,
Just throwing out options.
yeah, no, I don't think that's going to work at the moment. This is the only one that is now fashioned with that Thor camera on the back of the courtroom, so then that brings in a whole host of other issues that we cannot on the fly change at this juncture. We can not speak into the microphones. Nothing is heard in there if nothing is amplified out here.
And with that, Judge, of course, understanding that this is an extremely serious case for both sides, and I understand that the gallery on both sides may...
Whitaker case. I cannot stress this enough for everyone gathered here on both sides of the gallery. There shall be absolutely no emotional outbursts of any kind, regardless of what the verdict might be. If you think in your hearts that you cannot control your emotions or your voice, then I ask you now to leave this courtroom. Otherwise, you are welcome to stay, but I don't want to hear one peep out of anybody in the audience. Does everyone understand? Answer aloud. Yes. Is there anyone who doesn't understand? Please raise your hand. All right, and I see no hands raised. All right, you jeopardize the other case and the other trial if you do. So, no emotional outbursts. I don't think I can be any more clear. All right, do you want to switch tables and have Mr. Whitaker and Ms. Schlax in the front table? All right, if both sides are ready, then let's bring in Mr. Whitaker's jury. ladies and gentlemen, you may take your seats. And juror number 3, you're fine, yes. Has this jury reached a verdict? Can you please hand the verdict form over to the bailiff? All right, the court finds that there are no errors or omissions in the filling out of the verdict forms. Madam Clerk, can you please publish each verdict?
In the Circuit Court of the 4th Judicial Circuit in Georgia, Florida, case number 16-2020, CF3601, Division CRE, State of Florida versus Leroy Whitaker Jr. as to count 1. We, the jury, find the defendant guilty of first-degree murder as charged with evidence of St. Charles out of Jacksonville, Florida, fourth state dated July 31st, 2025. Verdict as to count 2. We, the jury, find the defendant guilty of charged in the indictment. We, the jury, further find the defendant convicted or battery during the course of the burglary. So said we all live in Jacksonville, Florida, 4% dated July 31st, 2025.
Does counsel for either the state or the defense desire the jury to be polled?
Yes, Your Honor.
All right, Madam Clerk, if you'll please poll each juror.
Yes, ma'am. Juror number 1 is issued your correct verdict. Juror number 2 is issued your correct verdict. Juror number 3 is issued your correct verdict.
He's number 5.
Sorry. Juror number 5 is issued your correct verdict. Juror number 6 is issued your correct verdict. Juror number 7 is issued your correct verdict. Juror number 8 is issued your correct verdict. Juror number 9 is issued your correct verdict. Juror number 10 is issued your correct verdict. Juror number 11 is issued your correct verdict. Juror number 12 is issued your correct verdict. Juror number 13 is issued your correct verdict. Yes. And juror number 14 is issued your correct verdict.
All right, ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in that jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. And we have recognized for hundreds of years that a jury's deliberations, discussions, and its votes should remain its private affair as long as you wish it. Therefore, the law gives you this unique privilege not to speak about the jury's work. Although you are now at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, or from those who might seek to find fault with you, or from the media, or from the attorneys, or elsewhere. So it will be up to you to decide whether to preserve your privacy as a juror. And with the rendering of these verdicts, your service here in the Duval County Courthouse over these past 2 weeks is now concluded. And I wish to thank you again for answering your summons last Monday, coming down to the courthouse to be part of the administration of justice. All of my prior admonitions and prohibitions that I've imposed upon you about talking to people, about looking things up, about seeing, reading, or hearing anything in the news media or social media, those are all now lifted. You are free to do those things if you wish. But I wish to genuinely and sincerely thank you for your time, your attention, and your service, despite our fits and starts and sometimes delays that has allowed us to conclude this matter here with you today. So again, many, many thanks. I will let you go with the bailiff, where you will then be able to retrieve your electronic devices, your personal items, again with this court's sincerest thanks and appreciation for your service. You are now excused and free to go. All right, counsel, if you will present your client before the bench. right, Mr. Whitaker, based upon the verdicts of the jury finding you guilty of these 2 counts as charged in the indictment in case 2020 CF 3601, the court will now hereby remand you to the custody of the Jacksonville Sheriff's Office. Any bonds previously set shall now be revoked. And is he entitled to a pre-sentence investigation report, Ms. Schlax?
Yes, Your Honor, it is.
Okay, then I will order the preparation of a pre-sentence investigation report prior to sentencing, and that does take approximately 30 days to prepare. So when do the parties want to come back for sentencing to be set? I have available, of course, any week 30 days from now would be end of August, so either the week of August 25th or the shorter week of September 2, Monday being a holiday.
Your Honor, if I could do the 8th, September 8th.
September
Monday,
8th?
you said I'm out of town.
Okay, does that work? All right, then we'll set this matter for Monday, September 8th for sentencing to be set. All right, that is it for Mr. Whitaker for today. Thank you. All right, then as to Mr. Robinson's jury, counsel, just be sure to leave your cell numbers with Madam Clerk so that if the jury has any questions or a verdict, we can easily and quickly reach you to return back to courtroom 407. If there is nothing else, anything from the state? No. Anything from Mr. Robinson?
No, Your Honor.
Okay, then we shall be in recess. And I just wanted to be certain of what is being requested. It just says sticky notes, whiteboard and markers if possible, table of contents of items, and flow chart / diagram of family tree. Is that correct? All right. Now, we don't have, I don't know, smartboard we don't have, but we have this white easel flip chart. Will that suffice? And we have markers and we have sticky notes. So those we're going to send back with you for your use. Table of contents of items. I'm not sure what you were requesting. Is it a listing of all the exhibits and evidence? Because if so, that was sent in with you. Okay. That should be in there. If you can't find us, let us know. But the clerks printed out the list of all the exhibits they've received, and it is in there. And then lastly, flow chart / diagram of family tree. Unless that document was moved into evidence, I cannot give you anything that was not moved into evidence. So I will be unable to provide you with that. But otherwise, ladies and gentlemen, you might now return to the jury room and continue deliberating your verdict. Okay, then again, we'll be in recess until we hear back from them with either another question We'll go back on the record. We're here with Mr. Hakeem Robinson, his counsel. Well, you need counsel for the state. All right, we are present now with Mr. Robinson, his counsel, and counsel for the state. I'm advised the jury has reached a verdict. Any reason we can't bring the jury out now and receive the verdict? All right, let's please bring the jury out. Thank you.
Your Honor, the jury's entered the courtroom.
All right, ladies and gentlemen, you may take your seats. And ma'am, juror number 3, are you the foreperson? And has this jury reached a verdict?
Yes, we have.
Can you please hand the verdict form to the bailiff? All right, the court finds that there are no errors or omissions in the filling out of the verdict form. Madam Clerk, can you please publish the verdict?
In the Circuit of the 4th Judicial Circuit in and for Duval County, Florida, case number 16, 2020, CF 3601B, Division CRE. State of Florida versus Hakeem Robinson, verdict as to count 1. We, the jury, found the defendant guilty of first-degree murder as charged in the indictment. So say we all, done, Jacksonville, Duval County, Florida, signed by the foreperson on July 31st, 2025.
Does counsel for either the state or defense desire the jury to be polled?
Yes, Your Honor.
All right, Madam Clerk, if you can please poll each juror.
Juror 1, is this your true and correct verdict? Juror 2, is this your true and correct verdict? Juror 3, is this your true and correct verdict?
Yes.
Juror 4, is this your true and correct verdict?
Yes.
Juror 5, is this your true and correct verdict?
Yes.
Juror 6, is this your true and correct verdict?
Yes.
Juror 7, is this your true and correct verdict? Juror 8, is this your true and correct verdict?
Yes.
Juror 9, is this your true and correct verdict? Juror 10, is this your true and correct verdict? Juror 11, is this your true and correct verdict? Juror 12, is this your true and correct verdict? Thank you.
All right, ladies and gentlemen, I wish to thank you for your time and your consideration of this case. I also wish to advise you of some very special privileges to be enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in that jury room except by court order. For many centuries, our society has relied upon juries for the consideration of difficult cases. And we have recognized for hundreds of years that a jury's deliberations, their discussions, and their votes should remain their private affair as long as they wish it. Therefore, the law gives you this unique privilege not to speak about the jury's work. Although you are now at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, or from those who might seek to find fault with you, or from the media from the attorneys or elsewhere. So it will be up to you to decide whether to preserve your privacy as a juror. And with the rendering of this verdict, ladies and gentlemen, your service in this courtroom over the past 2 weeks is now concluded. And all of my prior admonitions and prohibitions against looking at the news or reading the newspaper, listening to the radio, or going on social media, or talking to anyone, or looking up anything, all of those prohibitions are now lifted. You are free to do those things if you wish. Keep in mind, folks might want to speak to you, and you are free to speak to them. But again, you are also free to refuse to speak to them. I do want to thank you sincerely for answering your jury summons, coming to the courthouse 2 Mondays ago, and being part of the administration of justice. I say this every week when I have jury trials. Our system of justice, I believe, is the best system of justice in the world, and it wouldn't operate in the manner and method in which it does without citizens such as you who take the time, the consideration, and out your private lives to come down here to be part of our process. So I do sincerely and genuinely thank you. And at this time, ladies and gentlemen, you are now excused and free to go. All right, that jury has exited the courtroom. Of course, they need to cross over and exit through the other door, but until and before they do come out, counsel, if you will present your client before the bench. All right, Mr. Robinson, based on the verdict of the jury finding you guilty of the offense charged in the indictment in case number 2020 CF 3601, the court does hereby remand you to the custody of the Jacksonville Sheriff's Office, and your bond in this matter shall be revoked. Now, he is entitled to a pre-sentence investigation report. Is that sentencing no earlier than 30 days? When would the parties wish to return? I have the week of August. The same week as Mr. Whitaker? Okay. Are you all available to return the week of September 8th? Keep in mind, Monday would be a to-be-set date, and we would set the sentencing on a convenient day that week for all parties involved. Okay. And on the 8th, you all are free to appear via Zoom. That's just a scheduling date. That won't be the sentencing date. We'll pick a date on the 8th. All right, then we'll pass Mr. Robinson's case to September 8th for sentencing to be set. All right, thank you. All right, everyone is excused and free to go. I'll wait for the jury to leave. All right, the jury is now out of the courtroom. Anything we need to take up before we recess? Okay. All right, thank you all. We'll be in recess.